So now let's see the difference between the sale and agreement to sell. We have read both these concepts. What is the difference between these two? So the table represents the three parts. One is the basis of the difference. Second, they give the essentials of a sale, and then last is the agreement to sell. So firstly, let's differentiate on the basis of nature of contract. A sale is an executed contract, whereas agreement to sell is an executory contract. Because in the contract of sale, everything is being performed, nothing is being left on the part of the seller or on the part of the buyer. So that's why this is called as executed contract, in which both of the parties have performed. But in case of agreement to sell, this contract is yet to be performed, either by one party or by both of the parties. The performance is still left. So that's why this is being called as the executory contract. Second is transfer of ownership. In case of sale, ownership is transferred immediately. Immediately when the sale is being performed, when the activity is being performed, ownership is transferred. But in agreement to sell, ownership will be transferred at some future date upon the fulfillment of some certain conditions. That means in case of sale, there is an immediate transfer of ownership, and in agreement to sale, the ownership would be transferred in future, not with the contract. Third is risk of loss. In case of sale, risk of loss falls on the buyer, even if the goods are under the possession of the seller. Reason being, in the sale, ownership is being transferred. The possession of goods doesn't matter. The goods are with buyer or the goods are with the seller. The possession of goods does not matter. So, because the risk is with the owner of the goods, and in the case of sale, the possession of the goods may or may not be with the buyer, but the ownership of the goods is with the buyers. So the risk of loss would be immediately transferred to the buyer. But in case of agreement to sell, a risk of loss falls on seller, because the ownership is still with the seller. The risk only goes with the ownership. Where there is ownership, there would be the risk. In case of sale, consequences of breach. In case of default of buyer, the seller may sue for damages only, not for price. But if buyer does not pay the price, the seller may sue for the price. Because if in case of sale, the goods are not being transferred, the ownership is not being transferred by the seller, then the buyer may sue for the damages. But if the seller has transferred the ownership and buyer has not made the payment, the seller can sue for the price of the goods. Now, in case of agreement to sell, the buyer has only a personal remedy against the seller, and if the seller defaults, the buyer may sue only for delivery of goods or for damages. Next, on the basis of insolvency of the seller, if the seller is being declared insolvent in case of sale, the buyer is entitled to recover the goods from the official receiver. Reason being, when once the seller is being declared insolvent, all the goods are being transferred to the official receiver or the assignee, and the buyer has the right to recover all those goods from the official receiver. And in case of agreement to sell, buyer can claim only a rateable dividend but not the goods. Reason being, the ownership was not transferred to the buyer. Next, the basis of difference is journal and particular property. The contract of sale creates a right in rem. Right in rem means it is open for all, and agreement to sell creates right in person. Next, right of resale. In case of sale, seller cannot resell the goods because he has already transferred the ownership to one person. But in case of agreement to sell, the seller can sell the goods as the ownership is still with the seller, and he can sell those goods to the buyer or to someone else because the ownership is still not being transferred. Last, in case of insolvency of the buyer, if the buyer has become insolvent, then in case of sale, seller is bound to deliver the goods to the official receiver or the assignee. But in case of agreement to sell, if the buyer become insolvent before he pays for the goods, the seller may not part with the goods. He would not deliver the ownership of the goods. The goods will remain in the custody. The ownership of the goods will remain with the seller only. So these are the basis of the difference and the basic difference between the sale and agreement to